Hello everyone. Today I am going to give you a brief of the Shah Bano Begum case. The case is Shah Bano Begum versus Muhammad Ahmed Khan. In this case, Shah Bano is the wife and Muhammad Ahmed Khan was the husband. So what happened was Muhammad Ahmed Khan was also married to another woman, and he also had child with her. So due to inheritance dispute, uh, Muhammad Ahmed Khan threw his wife, who was 60 years old at that time, that is almost after 40 years of marriage. He threw her out and wanted a divorce from her. What happened was Muhammad Ahmed Khan, he was ready to pay her the meher amount, that is the consideration amount for marriage, and the also the consideration which is to be paid within the period to the wife by the husband as per the Muslim law. So he was ready to pay that. So but what happened was that the wife wanted that she should be paid the consideration amount even after the iddat period, as she was already 60 years old and she also had kids. So she was unable to maintain herself and she was asking for consideration even after the iddat period. Now iddat period here means 3 menstrual cycles, 3 lunar months, or if the wife is pregnant, then the birth of the child, then till the birth of the child. uh, okay, and these 3 months means 3 months after the divorce. So yes, so the husband was saying that the Muslim personal law and section 127 subsection 3b of CRPC says that the consideration amount is to be paid only till the iddat period. All right, so what Shah Bano did, she filed a petition for maintenance under section 125 of CRPC. So already, both of them, basically both of them was fighting for the consideration amount after to be paid after the iddat period. The husband was saying that I only have to pay it till the iddat period, that is for 3 months after the divorce. But the wife was asking for it even after that period because she was unable to maintain herself for her life, for the rest of her life. So yes, so but and this was the question, and there were two precedent cases that already existed that time, but still there was a clash. Still the case was not getting to the right direction. So what happened was, okay, so I'll tell you about the two precedent cases that existed that time. So these two cases are Bai Tahira versus Ali Hussain, Fazlumi versus Khadir Kali. So what happened in these two cases prior, that 5-judge bench of the Supreme Court sat and they had given a judgment that if Muslim women is unable to maintain herself, then the husband can be ordered by the court to pay the consideration amount even after the iddat period. So as per the preceding judgment, the case should have been sorted, and it should have just been done, but it wasn't. So what happened was, due to this case, made a lot of news that time. Okay, so Rajiv Gandhi government was prevailing. So to get a solution to this, what the government did, they made a new act, because they did not want to lose their Muslim vote bank that time. So if the government did not act in support of the Muslim people, it would have really harmed them. They would have lost their vote bank. So what they did, the government made a new act. The act is Muslim Women Protection of Rights on Divorce Act, 1986. Okay, so I'll tell you that line, that section which says about the consideration amount to be paid within the iddat period or after the iddat period. I'll tell you. So what they did was they inserted a clause, they inserted a section 3, subsection A, that protection and maintenance of women, of the wife is to be done by the husband within the iddat period. So this act was really called the Black Act that time, because they made the law, but it was not giving relief to the Muslim women. The question was still there. Okay, so it did not do any relief to the Muslim people. Okay, Muslim women basically. So what happened was, the act was still prevailing, and so in 2001 another case arose, that is the Daniel Latifi versus Union of India. Okay, so what happened, In this case, the constitutional validity of above law was questioned, and a 5-judge bench reinterpreted the above law. Okay, and it said that the consideration to be paid within the iddat period is compulsory, but a lump sum amount should also be paid even after the iddat period is over. So basically, they reinterpreted the new law, and the solution came. That's all for the case.